we proceed to give a cursory history of the attainments, the civil, social, business, and professional, and literary attainments of colored men and women, and challenge comparison with the world, according to circumstances in times past and present. Welcome to History's Flip Side. I'm Wally Jamal. But this chapter is going to deal with law enforcement in 1850. This chapter deals with the Fugitive Slave Law of 1850. There was already a Fugitive Slave Law in place, but the people of the North, exercising their states' rights, didn't recognize slavery. So free blacks and some whites would help runaway slaves make their way to freedom. The success of the Underground Railway, that's what they called it at the time, caused the South to hemorrhage money. They demanded that Congress do something to force the Northerners to comply with the existing Fugitive Slave Law like they were supposed to. The Southern slaveholding Democrats in Congress were told that the Northern states were exercising their states' rights, not to uphold a law they deemed unconstitutional, and that it was just flat out wrong to own other people. But then, all hell broke loose. Gold was discovered in the California Territory in 1849 at Sutter's Mill. Immediately, the Southern Democrats were fighting in Congress against the Northern anti-slavery Republicans, which were known then as the Whigs, over whether the California Territory would be a free soil state or a slave state. And that's when the Great Compromise of 1850 took place. The South agreed not to fight for California statehood status if Congress took up a newer, much harsher version of the Fugitive Slave Bill to be signed into law, which now, regardless of Northern states' rights, would be rigorously enforced on the Northern white people. On this episode of the Delaney Papers, we present to you this amendment to the U.S. Constitution, which I believe still is affecting police enforcement of today in the hearts and minds of many white Americans. So here it is, the Fugitive Slave Law of 1850, on Chapter 16 of the Delaney Papers. Chapter 16, National Disfranchisement of Colored People. We give below the Act of Congress known as the Fugitive Slave Law for the benefit of the reader, as there are thousands of the American people of all classes who have never read the provisions of this enactment and consequently have no conception of its enormity. We had originally intended also to have inserted here the Act of Congress of 1793, but since this bill includes all the provisions of that act, in fact, also called a supplement, is a substitute de facto. It would be superfluous, therefore, we insert the bill alone with explanations following. An act to amend and supplementary to the act entitled An Act Respecting Fugitives from Justice and Persons Escaping from the Service of Their Masters. Approved February 12, 1793. Section 1. Be it enacted by the Senate and the House of Representatives of the United States in Congress assembled, that the persons who have been or may hereafter be appointed commissioners in virtue of any act of Congress by the circuit courts of the United States, and who, in consequence of such appointment, are authorized to exercise the powers that any justice of the peace or other magistrate of any of the United States may exercise in respect to offenders for any crime or offense against the United States by arresting, imprisoning, or bailing the same under and by virtue of the 33rd section of the Act of the 24th of September, 1789, entitled, An Act to Establish the Judicial Courts of the United States, shall be, and hereby authorized and required to exercise and discharge all the powers and duties conferred by this act. Section 2. And be it further enacted that the Superior Court of each organized territory of the United States shall have the same power to appoint commissioners to take acknowledgments of bail and affidavit, and to take depositions of witnesses in civil causes, which is now possessed by the circuit courts of the United States, and all commissioners who shall hereafter be appointed for such purposes by the Superior Court of any organized territory of the United States shall possess all the powers and exercise all the duties conferred by law upon the commissioners appointed by the circuit courts of the United States for the similar purposes, and shall moreover exercise and discharge all the powers and duties conferred by this act. Section 3. And be it further enacted that the circuit courts of the United States and the superior courts of each organized territory of the United States shall, from time to time, enlarge the number of commissioners with a view to afford reasonable facilities to reclaim fugitives from labor and to the prompt discharge of the duties imposed by this act. Section 4. And be it further enacted that the commissioners above named shall have concurrent jurisdiction with the judges of the circuit and district courts of the United States in the respective circuits and districts within the several states, and the judges of the superior courts of the territories severally and collectively in term time and vacation, and shall grant certificates to such claimants upon satisfactory proof being made, with authority to take and remove such fugitives from service or labor under the restrictions herein contained to the state or territory from which such persons may have escaped or fled. Section 5. And be it further enacted that it shall be the duty of all marshals and deputy marshals to obey and execute all warrants and precepts issued under the provisions of this act when to them directed, and should any marshal or deputy marshal refuse to receive such warrant or other process when tendered, or to use all proper means diligently to execute the same, he shall, on conviction thereof, be fined in the sum of $1,000 to the use of such claimant, on the motion of such claimant, by the circuit or district court for the district of such marshal, and after arrest of such fugitive by such marshal or his deputy, or whilst at any time while in his custody, under the provisions of this act, should fugitive escape, whether with or without the assent of such marshal or his deputy, such marshal shall be liable on his official bond to be prosecuted for the benefit of such claimant for the full value of the service or labor of said fugitive in the state territory, or district whence he escaped, and the better to enable the said commissioners, when thus appointed, to execute their duties faithfully and efficiently in conformity with the requirements of the Constitution of the United States and of this art. They are hereby authorized and empowered within their counties respectively to appoint in writing under their hands any one or more suitable persons from time to time to execute all such warrants and other process as may be issued by them in the lawful performance of their respective duties, with an authority to such commissioners or the persons appointed by them to execute process as aforesaid, to summon and call to their aid bystanders or posse comitatus of the proper county when necessary to ensure a faithful observance of the clause of the Constitution referred to, in conformity with the provisions of this act, and all good citizens are hereby commanded to aid and assist in the prompt and efficient execution of this law whenever their services may be required, as aforesaid, for that person, and said warrants shall run and be executed by said officers anywhere in the state within which they are issued. Section 6. And be it further enacted, that when a person held to service or labor in any state or territory of the United States has heretofore or shall hereafter escape into another state or territory of the United States, the person or persons to whom such service or labor may be due, or his, her, or their agent or attorney, duly authorized in writing, acknowledged and certified under the seal of some legal office or court of the state or the territory in which the game may be executed, may pursue and reclaim such fugitive person, either by procuring a warrant from someone of the courts, judges, or commissioners, as aforesaid, of the proper circuit, district, or county for the apprehension of such fugitive, where the same can be done without process, and by taking and causing such person to be taken forthwith before such court, judge, or commissioner, whose duty it shall be to hear and determine the case of such claimant in a summary manner, and upon satisfactory proof being made, by deposition or affidavit in writing, to be taken and certified by such court, judge, or commissioner, or by other satisfactory testimony duly taken and certified by some court, judge, or commissioner, or by other satisfactory testimony duly taken by some court, magistrate, justice of the peace, or other legal officer, authorized to administer an oath and to take depositions under the laws of the state or territory from which such person, owing service or labor, may have escaped, with a certificate of such magistracy or other authority, as aforesaid, with the seal of the proper court or officer thereto attached, which seal shall be sufficient to establish the competency of proof, and with proof also by affidavit of the identity of the person whose service or labor is claimed to be due, as aforesaid, that the person so arrested does in fact owe service or labor to the person or persons claiming him or her in the state or territory from which such fugitive may have escaped, as aforesaid, and that said person escaped, to make out and deliver to such claimant his or her agent or attorney, a certificate setting forth the substantial facts as to the service or labor due from such fugitive to the claimant, and of his or her escape from the state or territory in which he or she was arrested, with authority to such claimant or his or her agent or attorney to use such reasonable force and restraint as may be necessary under the circumstances of the case to take and remove such fugitive back to the state or territory from whence he or she may have escaped as aforesaid. In no trial, or hearing under this act shall the testimony of such fugitive be admitted in evidence, and the certificates in this and the first section mentioned shall be conclusive of the right of the person or persons in whose favor granted to remove such fugitive to the state or territory from which he escaped, and shall prevent all molestation of said person or persons by any process issued by any court, judge, magistrate, or other person whomsoever. Section 7. And be it further enacted, that any person who shall knowingly or willingly obstruct, hinder, or prevent such claimant, his agent or attorney, or any person or persons lawfully assisting him, her, or them from arresting such a fugitive from service or labor, either with or without process as aforesaid, or shall rescue or attempt to rescue such fugitive from service or labor from the custody of such claimant, his or her agent or attorney, or other person or persons lawfully assisting him, as aforesaid, when so arrested, pursuant to the authority therein given and declared, or shall aid, abet, or assist such person, so owing service or labor as aforesaid, directly or indirectly, to escape from such claimant, his agent or attorney, or other person or persons legally authorized as aforesaid, or shall harbor or conceal such fugitive so as to prevent the discovery and arrest of such person after notice or knowledge of the fact that such person was a fugitive from service or labor as aforesaid, shall, for either of said offenses, be subject to a fine not exceeding $1,000 and imprisonment not exceeding 6 months by indictment and conviction before the district courts of the United States for the district in which such offense may have been committed, or before the proper court of criminal jurisdiction if committed within any one of the organized territories of the United States, and shall moreover forfeit and pay by way of civil damages to the party injured by such illegal conduct the sum of $1,000 for each fugitive so lost as aforesaid, to be recovered by action of debt in any of the district or territorial courts aforesaid, within whose jurisdiction the said offense may have been committed. Section 8. And be it further enacted, that the marshals, their deputies, and the clerks of the said district and territorial courts shall be paid for their services the like fees as may be allowed to them for similar services in other cases, and where such services rendered exclusively in the arrest, custody, and delivery of the fugitive to the claimant, his or her agent or attorney, or where such supposed fugitive may be discharged out of custody for the want of sufficient proof as aforesaid, then such fees are to be paid in the whole by such claimant his agent or attorney, and in all cases where the proceedings are before a commissioner, he shall be entitled a fee of $10 in full for his services in each case upon delivery of the said certificate to the claimant, his or her agent or attorney, or a fee of $5 in cases where the proof shall not, in the opinion of such commissioner, warrant such certificate and delivery, inclusive of all services incident to such arrest and examination, to be paid in either case by the claimant, his or her agent or attorney, the person or persons authorized to execute the process to be issued by such commissioners for the arrest and detention of fugitives from service or labor as aforesaid, shall also be entitled to a fee of $5 each for each person he or they may arrest and take before any such commissioner as aforesaid at the instance and request of such claimant, with such other fees as may be deemed reasonable by such commissioner for such other additional services as may be necessarily performed by him or them, such as attending to the examination, keeping the fugitive in custody, and providing him with food and lodging during his detention, and until the final determination of such commissioner, and in general for performing such other duties as may be required by such claimant, his or her agent or attorney or commissioner in the premises. Such fees to be made up in conformity with the fees usually charged by the officers of the courts of justice within the proper district or county as near as may be practicable, and paid by such claimants, their agents or attorneys, whether such supposed fugitive from service or labor be ordered to be delivered to such claimants by the final determination of such commissioners or not. Section 9. And be it further enacted that upon affidavit made by the claimant of such fugitive, his agent or attorney, after such certificate has been issued, that he has reason to apprehend that such fugitive will be rescued by force from his or their possession before he can be taken beyond the limits of the state in which the arrest is made, it shall be the duty of the officer making the arrest to retain such fugitive in his custody and remove him to the state whence he fled, and there to deliver him to said claimant, his agent or attorney. And to this end, the officer and his assistants, while so employed, to receive the same compensation and to be allowed the same expenses as are now allowed by law for the transportation of criminals, to be certified by the judge of the district within which the arrest is made and paid out of the United States Treasury. And finally, Section 10. And be it further enacted that when any person held to service or labor in any state or territory or in the District of Columbia shall escape therefrom, the party of whom such service or labor shall be due, his, her, or their agent or attorney, may apply to any court of record therein, or judge thereof, in vacation, and make satisfactory proof to such court or judge in vacation of the escape aforesaid, and that the person escaping owed service or labor to such party, whereupon the court shall cause a record to be made of the matter so proved, and also a general description of the person so escaping, with such convenient certainty as may be, and a transcript of such record authenticated by the attestation of the clerk and of the seal of the said court, being produced in any other state, territory, or district in which the person so escaping may be found, and being exhibited to any judge, commissioner, or other officer authorized by the law of the United States to cause persons escaping from service or labor to be delivered up, shall be held and taken to be full and conclusive evidence of the fact of escape, and that the service or labor of the person escaping is due to the party in such a record mentioned, and upon the production by the said party and other or further evidence, if necessary, either oral or by affidavit, in addition to what is contained in the record of the identity of the person escaping, he or she shall be delivered up to the claimant, and the said court, commissioner, judge, or other person authorized by this act to grant certificates to claimants of fugitives shall, upon the production of the record and other evidences aforesaid, grant to such claimant a certificate of his right to take any such person identified and proved to be owing service or labor as aforesaid, which certificate shall authorize such claimant to seize or arrest and transport such person to the state or territory from which he escaped, provided that nothing herein contained shall be construed as requiring the production of a transcript of such record as evidence as aforesaid. But in its absence, the claim shall be heard and determined upon other satisfactory proofs competent in law. Howell Cobb, Speaker of the House of Representatives. William Rufus King, President of the Senate pro tempore. Approved September 18th, 1850, by President Millard Fillmore. The most prominent provisions of the Constitution of the United States, and those which form the fundamental basis of personal security, are they which provide that every person shall be secure in their own person and property, that no person may be deprived of liberty without due process of law, and that for crime and misdemeanor, that there may be no process of law that shall work corruption of blood. By corruption of blood is meant that process by which a person is degraded and deprived of rights common to the enfranchised citizen, of the rights of an elector, and of eligibility to the office of a representative of the people. In a word, that no person, nor their posterity, may ever be debased beneath the level of the recognized basis of American citizenship. This debasement and degradation is corruption of blood. Politically understood, a legal acknowledgement of inferiority of birth. Heretofore, it has ever been denied that the United States recognized or knew any difference between the people, that the Constitution makes no distinction, but includes in its provision all the people alike. This is not true, and certainly is blind absurdity, in us at least, who have suffered the dread consequences of this delusion, not now to see it. by the provisions of this bill, the colored people of the United States are positively degraded beneath the level of the whites, are made liable at any time, in any place, and under all circumstances to be arrested and upon the claim of any white person, without the privilege of even making a defense, sent into endless bondage. Let no visionary nonsense about habeas corpus or fair trial deceive us. There are no such rights granted in this bill. And except where the commissioner is either too ignorant to understand when reading it or too stupid to enforce it when he does understand, there is no earthly chance, no hope under heaven for the colored people that is brought before one of these officers of the law. Any leniency that may be expected must proceed from the whims or caprice of the magistrate. In fact, it is optional with them, and our rights and liberty entirely at their disposal. We are slaves in the midst of freedom, waiting patiently and unconcernedly, indifferently and stupidly for masters to come and lay claim to us, trusting to their generosity whether or not they will own us and carry us into endless bondage. The slave is more secure than we. He knows who holds the heel upon his bosom. We know not the wretch who may grasp us by the throat. His master may be a man of some conscientious scruples. Ours may be unmerciful. Good or bad, mild or harsh, easy or hard, lenient or severe, saint or Satan. Whenever that master demands any one of us, even our affectionate wives and darling children, we must go into slavery. There is no alternative. The will of the man who sits in judgment of our liberty is the law. To him is given all the power to say whether or not we have a right to enjoy freedom. This is the power over the slave in the South. This is now extended in the North. The will of the man who sits in judgment over us is the law, because it is explicitly provided that the decision of the commissioner shall be final, from which there can be no appeal. The freedman of the South is even more secure than the freeborn of the North, because such persons usually have their records in the slave states, bringing their papers with them, and the slaveholders will be faithful to their own acts. The northern freeman knows no records. He despises the papers. Depend upon no promised protection of citizens in any quarter. Their own property and liberty are jeopardized, and they will not sacrifice them for us. We may not expect them to do so. Besides, there are no people who ever lived who love their country and obey their laws as the Americans. Their country is their heaven, their laws their scriptures, and the decrees of their magistrates obeyed as the fiat of God. It is the most consummate delusion and misdirected confidence to depend upon them for protection, and for a moment suppose even our children safe while walking the streets among them. A people capable of originating and sustaining such a law as this are not the people to whom we are willing to entrust our liberty at discretion. What can we do? What shall we do? This is the great and important question. Shall we submit to be dragged like brutes before heartless men and sent into degradation and bondage? Shall we fly, or shall we resist? Ponder well and reflect. A learned jurist in the United States, Chief Justice John Gibson of Pennsylvania, lays down this as a fundamental right in the United States: that every man's house is his castle, and he has the right to defend it unto taking of life against any attempt to enter it against his will, except for crime by well-authenticated process. But we have no such right. It was not intended for us, any more than any other provision of the law, intended for the protection of Americans. The policy is against us. It is useless to contend against it. This is the law of the land and must be obeyed, and we candidly advise that it is useless for us to contend against it. To suppose its repeal is to anticipate the overthrow of the Confederative Union. And we must be allowed an expression of opinion when we say that we candidly believe the existence of the Fugitive Slave Law necessary to the continuance of the National Compact. This law is the foundation of the compromise. Remove it, and the consequences are easily determined. We say necessary to the continuance of the National Compact. We certainly will not be understood as meaning that the enactment of such a law was really necessary, or as favoring in the least this political monstrosity, the 31st Congress of the United States of America. Surely not at all. But we speak logically and politically, leaving morality and right out of the question, taking our position on the acknowledged popular basis of American policy, arguing from premise to conclusion. We must abandon all vague theory and look at facts as they really are, viewing ourselves in our true political position in the body politic. To imagine ourselves to be included in the body politic, except by express legislation, is at war with common sense and contrary to fact. Legislation, the administration of the laws of the country, and the exercise of rights by the people all prove to the contrary. We are politically not of them, but alien to the laws and political privileges of the country. These are truths, fixed facts, that quaint theory and exhausted moralizing are impregnable to and fall harmlessly before. It is useless to talk about our rights in individual states. We can have no rights here as citizens not recognized in our own common country. As citizens of one state are entitled to the rights and privileges of an American citizen in all of the states. The nullity of the one necessarily implying the nullity of the other. These provisions then do not include the colored people of the United States, since there is no power left in them, whereby they may protect us as their own citizens. Our descent by the laws of the country stamps us with inferiority. Upon us has this law worked corruption of blood. We are in the hands of the general government, and no state can rescue us. The Army and Navy stand at the service of our enslavers, the whole force of which may at any moment, even in the dead of night, as has been done when sunk in the depth of slumber, called out for the purpose of forcing our mothers, sisters, wives, and children, or ourselves into hopeless servitude, there to weary out a miserable life of relief from which death would be hailed with joy. Heaven and earth, God and humanity, are not these sufficient to arouse the most worthless among mankind of whatever descent to a sense of their true position? These laws apply to us. Shall we not be aroused? What then shall we do? What is the remedy? Is the important question to be answered. This important inquiry we shall answer and find a remedy when treating of the emigration of the colored people. Wow. Needed a good hit of Joe after that. My goodness, Martin Delany. What a passionate writer. And what a time of absolute terror. If you had this, according to this law, you were a born criminal. A born criminal. A fugitive from service or labor. And how'd you like those candy coating, that sweet candy coating they made for the slave catchers? Commissioner, marshal, deputy marshal, officer, agent. Not once in the Fugitive Slave Law did you hear the word slave or slave catcher. What sugar-coated BS, huh? All to totally take away the rights of an unoffending people and let it be known. Why couldn't they just put it in the Constitution that they were excluding black people from all those ideals of freedom and liberty? Why couldn't they just be man enough to do that? That's what I wanted to know. A lot of them said the same thing. A lot of Southerners said, dude, you ought to change the Constitution and all that. You ought to change it. All men created equal? No. That's not what we do. And they were saying it. But I guess they had to have their cover story. But yes, this law, it worked corruption. And in my opinion, I couldn't think all this time when learning about the Civil War, which Martin Delany all but predicts will happen if they try to abolish this law, is necessary to the continuance of the National Compact. And when did you ever hear the term Confederative Union? You see, this was 1852, 9 years before the first shot on Fort Sumter happened. This book, it's explosive. There's some explosive elements to it. And the book is on its way. It's on its way, and it will be available on Amazon. But in the meantime, I have compiled an audio book of this book. It's 7 hours and 20 minutes of Martin Delany in 1852. The chapters include colored American warriors, colored businessmen, colored literary. This digitally mastered audiobook of the Delany Papers is 7 hours, 22 minutes. Volumes 1, 2, and 3 each have 2 CDs, and Volume 4 contains 1 and a humble personal thank you from me. Each 2 CD volume is $20, but you can get all 4 volumes for $50.